Ready? Start. The petitioner was thus within his authority to pass the order that was ultimately quashed by the High Court in the aforesaid CWP, but then the order passed by him was certainly within jurisdiction and could not be condemned as sans jurisdiction. Stop. Learned senior counsel then contended that there is no iota of evidence anywhere even till this date, and even in response to the present petition, that she is the niece of the petitioner as claimed, and the said fact was denied. Stop. Even otherwise, she has returned the land and her claim. Stop. The petitioner was entitled to protection under Section 2 of the Judges Protection Act 1985 as he discharged his function as a judge within the meaning of provisions of the said act, and therefore the petitioner ought to be protected as he did not act without jurisdiction and had the authority to pass the order. Stop. At any rate, according to him, passing of a judicial or quasi-judicial order cannot lead to any criminal action against the quasi-judicial authority passing the order, and the law is settled accordingly. Stop. Learned senior counsel for the petitioner then invited my attention to the judgment made by the tribunal in the same subject matter as the petitioner was proceeded in a departmental inquiry that was ordered to be held against him. Stop. The petitioner had challenged the charge sheet itself, so also the appointment of inquiry officer before the tribunal, and the tribunal had recorded categorical findings which have attained finality. Stop. Learned senior counsel has cited some judgments. Stop. The judgment passed by the tribunal is the judgment having full sanctity in law and would operate with full force because the subject matter of the FIR and the said judgment of the tribunal is the same without even any slightest difference. Stop. In this context, it is significant to notice that even Office of the Director Consolidation on security of the application filed by them did not raise any objection to the maintainability of the said applicant under Section 42 of the Act, although Assistant District Attorney / Law Officer was also posted in the office. Stop. Consolidation officer also appeared during the hearing before the applicant and did not raise any objection to the maintainability of the application under Section 42 of the Consolidation Act. Stop. The applicant remained posted as Director Consolidation for 3 months only. Stop. Consequently, he had to depend on the precedents of the predecessors and also on office briefing. Stop. Besides, much more significantly, mere error of law in passing any order without anything more is no ground to initiate disciplinary action against judicial / quasi-judicial authority passing the order. Stop. In the instant case, the whole basis of the impugned charge sheet is order dated 10/11/2008. Stop.